Welcome to Think Outside the Box, a deep dive.
It's great to have you with us.
Absolutely. And right up front, we want to make something clear. This deep dive, it's actually designed as part of Teacher Victoria's ESL class.
That's right. We're exploring complex topics together.
Exactly. So if anything we discuss, sparks a question, or maybe you just want to learn more about the class itself, please do reach out to Teacher Victoria.
Yeah, definitely drop your message.
And also, just the standard but important note, everything we're talking about today is purely for educational purposes.
Absolutely. This isn't legal advice. We're analyzing source material,
Right.
trying to understand it. That's the goal.
Got it. Okay, so today we are diving deep into something specific and, well, based on the sources you shared, something pretty controversial. California Civil Code, Section 47.1.
Yeah, it's generated some discussion. We've got a few sources lined up. First, there's the actual text of the law itself. What does it say?
The primary source, okay?
Then we have two other pieces. Commentary, analysis. They really dig into how this law might play out in the real world.
And I understand they discuss a specific high-profile case.
They do, yeah. That helps illustrate the points they're making.
Okay, so our mission for this deep dive is, well, let's unpack this law. What does the text tell us are its core provisions? What seems to be its intended purpose, just based on the language?
And then, crucially, what are the big arguments the other sources make about its actual impact, its consequences, potential problems?
Right. Using that Baldoni lively case, as discussed in those sources, as a key example.
Exactly. That's the plan.
Perfect. Let's start with the foundation then, the law itself. According to that legal text, what's the main thing California Civil Code Section 47.1 actually does?
Okay, so based on the text, the core idea is granting a special kind of protection. It says a communication, specifically one made by an individual.
Okay.
And this is key, without malice, regarding an incident of SA, SH, or discrimination. Well, that communication is considered privileged.
Privileged. Okay, let's pause on those acronyms, SA and SH, just for clarity, especially for our ESL listeners.
Good point.
When we say SA or SH, in the context of this law and these sources, and the law also mentions discrimination.
Correct. Serious issues. So this privilege applies to communications about those things.
So what does privileged mean here? In this legal context, why is that word so important?
Right. It's important because of defamation lawsuits. That's where this privilege comes into play. It essentially acts as a shield.
Shield.
Yeah. If someone makes a statement about SA, SH, or discrimination, and it's privileged under 47.1, they get significant protection if the person they accuse tries to sue them for defamation.
Okay, protection. How exactly? What does that look like?
Well, the law spells it out. If you get sued for defamation over one of these privileged communications and you successfully defend yourself, you win the case, you're entitled to get your reasonable attorney's fees and costs back.
Okay, just getting your legal costs covered if you win, that's already a big deal. Lawsuits are expensive.
They are.
Yeah.
But it doesn't stop there. The law actually goes further.
Oh.
It also says if you win that defamation defense, you can potentially recover treble damages.
Treble damages. So 3 times the amount of any actual harm caused by the defamation lawsuit itself.
That's right. And on top of that, potentially punitive damages too.
Wow. Punitive damages. That's about punishment, right? So fees back, triple damages for the harm of the suit, and damages meant to penalize the person who sued you. That sounds like a really, really strong defense.
It is. It creates a very powerful deterrent against even bringing defamation suits related to these kinds of communications, and significant compensation if the defendant wins.
Is this protection automatic? Does it apply to any statement someone makes about SA, SH, or discrimination?
No, and that's a really key limitation mentioned right in the text. This privilege only applies to an individual who had, or at any time had, a reasonable basis to file a complaint of SA, SH, or discrimination.
Reasonable basis, okay.
And importantly, this applies whether or not they actually did file a formal complaint.
Ah, okay. So you don't have to have gone through the whole formal process, but there needed to be, legitimate grounds for thinking about a complaint in the first place. A reasonable basis.
That seems to be the idea captured in the text, yes. It ties the protection back to the underlying situation, not just the act of communicating.
And the law defines communication pretty broadly too, right? It's not just formal statements.
It is quite broad, yes. The text defines communication as factual information related to an incident of SA, SH, or discrimination experienced by the individual making the communication.
Experienced by the individual making it. Got it. And what kinds of incidents does it specifically mention?
The law lists examples to clarify the scope. It includes acts of SA, obviously.
Right.
Acts of SH. And it points to another specific law section for definition.
Okay.
It also covers communications about workplace issues, things like harassment, discrimination, an employer failing to prevent it, aiding it, or retaliating. It cites specific government codes there.
So workplace stuff is definitely included.
Yes. And housing issues, too. Harassment, discrimination, retaliation, and housing, again citing specific codes.
Housing too, okay.
And education, SH in schools, harassment, or discrimination based on protected characteristics in education settings.
Makes sense.
Even cyber SA bullying is specifically mentioned, referencing the education code.
Cyber SA bullying. So it really does span a lot of different areas: workplace, housing, schools, online. It's not just one narrow type of setting.
It seems quite comprehensive in its scope based on those examples.
And this law is fairly new.
Yes. The sources note it was added effective January 1st, 2024, so relatively recent.
Okay, so just to recap the law itself based on the text. It protects individuals making communications about SA, SH, or discrimination. Key conditions are no malice, and they had a reasonable basis for a complaint, filed or not. And the protection is strong, potentially covering legal fees, treble damages, and punitive damages if they successfully defend a defamation suit.
That captures the essence of the mechanism described in the legal text, yes.
Okay, now let's pivot to the other sources. Because while that sounds like protection for people speaking out, these sources argue it's, well, not so simple. They say it creates real problems.
They definitely present a critical view. They argue that the law, whatever its intent, ends up, as they put it, tipping the scales of justice too far.
Tipping the scales? How so?
Their point is that justice requires balance. It needs to protect both sides. And truth, they argue, should come from evidence, not just from someone's belief or statement, however genuinely held.
And they connect this to fundamental legal principles, like presumption of innocence.
Exactly. That's a core part of their critique. They argue this law sort of blurs the line on innocent until proven guilty and the burden of proof.
How?
Well, normally if you accuse someone, the burden is on you to prove it. But here, by shielding these statements from defamation suits, even potentially false ones, as long as there's no malice, they argue, it takes away the accused person's main tool for challenging the claim in court.
Because winning a defamation suit becomes incredibly hard. You have to prove actual malice.
Precisely. And proving actual malice, that the person knew it was false or showed reckless disregard for the truth, is an extremely high legal bar. The sources really emphasize how difficult that is.
So the accused might be stuck, unable to use defamation law to argue the original statement was simply false and damaging, unless they can somehow prove this very specific, malicious state of mind.
That's the consequence the sources are pointing to. It limits the accused's recourse.
And this ties into their argument about belief versus fact.
Yes. They contend that Section 47.1, in practice, gives significant legal weight to someone's personal belief or non-malicious conviction, potentially prioritizing it over provable fact.
Which they see as dangerous.
Yes, dangerous because accusations, even if based on a genuine but mistaken belief, can absolutely destroy someone's reputation and life. Their position is that the courtroom should be about facts and evidence.
So the worry is, the law protects statements made without provable malice, even if factually incorrect, making it tough for the accused to clear their name through the courts.
That's the core of their accountability critique. They argue the immunity under 47.1 acts like a cloak. It shields the accuser from legal blowback for their statement, even if it's later shown to be unfounded, unless that very high bar of actual malice is met. Harm is done, but legal remedy is restricted.
Okay, this seems like the perfect point to bring in the Baldoni Lively case, which the sources use as a real-world illustration.
Exactly. They use this case to show how they believe Section 47.1 functions in practice and why they're concerned.
So, according to these sources, what are the basic facts of that case?
The sources describe that Blake Lively filed a SH complaint. She filed with the California Civil Rights Department and also initiated a lawsuit against Justin Baldoni alleging misconduct.
Okay, and Baldoni's response. What do the sources say he did?
They state he responded with a very large countersuit, reportedly $400 million.
$400 million. Wow.
Yeah, against Lively for defamation and also extortion. His claim, according to the sources, was that her accusations were false and part of a conspiracy.
So a massive counterclaim. How did that play out in court, based on the source's account?
Well, according to the sources, a federal judge dismissed Baldoni's $400 million suit.
Dismissed it. On what grounds?
The sources say the dismissal was based specifically on California Civil Code, Section 47.1.
So the very law we're discussing was applied directly here. How did the sources explain the court's reasoning? Why did 47.1 lead to dismissal?
The sources state the court ruled Lively's communications, like her reports to the government agency and related public statements, as presented in the sources, were protected. Protected by Section 47.1 because they fell under that privilege, assuming they weren't made with malice.
So because of the privilege.
Right, which meant Baldoni's defamation claim couldn't proceed unless he could meet that incredibly high standard of proving actual malice on Lively's part.
Which, as we said, the sources stress is extremely difficult.
Exactly.
So how do these critical sources use this specific outcome to bolster their arguments against Section 47.1?
Well, they frame it as a clear example of their concerns. They argue it shows the law giving the accuser, Lively in this case, a potent civil shield against the defamation claim.
While the accused,
Baldoni, they argue, was left without a practical legal way to actually challenge the substance of the accusations in court or clear his name. All because he likely couldn't meet the actual malice standard required to get past the 47.1 privilege.
And the sources mention real-world consequences for Baldoni.
Yes, they highlight reports of significant damage, things like canceled appearances, intense media scrutiny, serious reputational harm. And they argue this happened without him having what they consider a fair shot in court, like a defamation trial, to contest the claims with evidence.
And does this connect back to their belief versus fact point?
It does. The sources suggest the dismissal was based on the fact that Lively had reported an incident and had a reasonable basis fulfilling the conditions of 47.1, rather than requiring proof of the underlying accusation's truth in that proceeding.
So they see it as the law working as designed, but with the outcome being that belief, or at least the act of reporting with a reasonable basis, effectively prevented a factual challenge via defamation.
That's how they frame it, yes. They argue it illustrates their point that belief supplants proof when it comes to the accused's ability to fight back against the statement itself using defamation law under 47.1.
One source used some pretty strong language, calling it dead before evidence was ever weighed.
Yes, that source really emphasizes this, calling the law a weaponized loophole. Their argument is that 47.1 allowed the dismissal based on the legal shield itself, preventing Baldoni from getting, as they put it, his day in court to actually debate the facts of the accusations.
So for these sources, the Baldoni-Lively case exemplifies how 47.1 can, in their view, create a significant legal imbalance, protecting accusers from defamation suits while potentially denying the accused a viable path to challenge the truthfulness of the claims unless they can clear that very high malice hurdle.
That's precisely the narrative these particular sources construct around the case, linking it directly to their critique of the law's impact.
Okay, before we move to broader concerns, just a quick reminder. This deep dive is part of Teacher Victoria's ESL class.
That's right.
We genuinely hope exploring sources like this is helpful for your learning. And seriously, if you have questions or want to know more about the class, please do reach out to Teacher Victoria.
Absolutely. Engaging with this kind of material is it's a great way to learn.
Okay, so beyond this specific case, the sources also raise some wider concerns, right? About the law's potential impact generally, even constitutionality.
They do. They touch on potential constitutional issues. The argument is that by giving such a strong shield to one side, the accusers, against defamation, while severely limiting the other side's ability to respond legally without proving malice, well, it raises questions.
Questions about what specifically?
About fundamental legal principles like equal protection under the law and due process.
Equal protection, meaning the law should apply fairly to everyone, and due process, meaning you have a right to a fair legal process, like defending yourself. The sources think this law might undermine those.
That's the concern they articulate, yes. That it might be tilting the scales in a way that impacts those core rights. They also worry about the sheer breadth of communication covered.
Right, we touched on that. It's not just formal stuff.
Exactly. The protection could potentially cover informal statements too. Social media posts, emails, maybe even, as one source suggests, gossip or whispers.
Wow.
Which, they argue, makes it incredibly hard for someone to counter damaging claims made almost anywhere, because a speaker might be shielded by 47.1 unless you can prove malice.
And they use some hypothetical examples to make this really concrete for listeners.
Yeah, those hypotheticals are quite stark. The small-town teacher one, for instance.
Tell us about that one.
Imagine a teacher falsely accused by a parent. Let's say the parent genuinely but mistakenly believes the accusation. Even if the school investigates and finds zero evidence, the sources argue 47.1 could shield that parent from a defamation suit.
So the teacher's reputation is damaged, maybe their career impacted.
Right. Shunned, students withdrawn, etc. But potentially no legal recourse against the parent's damaging statement unless they can prove malice, which might be impossible if the parent truly believed it.
The harm is real, but the legal path to address the source of the harm is blocked. That's the argument.
That's the argument. And the professor example is similar. Accused years later by a former student, maybe no evidence corroborates it, maybe the university clears him.
But the damage is done.
Exactly. Career ruined, life upended. And again, the sources argue, under 47.1, he probably can't sue for defamation unless he can prove the student acted with malice. That almost impossible standard again.
They use that phrase, legalized destruction by accusation.
Yes, it's very strong language. It's meant to convey their view that the law, as it stands, could allow accusations, even unsubstantiated ones, to cause devastating, irreversible reputational harm without giving the accused an adequate legal way to fight back and restore their name, short of proving malice.
Okay. So summing up the core argument from these critical sources, California Civil Code 47.1, while maybe intended to protect survivors and encourage reporting.
These sources argue it goes too far. It risks creating a new imbalance. It could potentially victimize the accused by denying them meaningful recourse, stifle important nuance, and ultimately prioritize protection from accountability over truth, evidence, and fairness.
And their conclusion seems to be about finding that balance again.
Yes, they keep coming back to that justice demands balance, fairness for both sides, and processes based on evidence. They see 47.1 as disrupting that balance in this specific area.
This has been a really fascinating and deep dive into a complex law and some very significant criticisms raised in these sources. It really highlights the tough balancing act involved.
It certainly does. It shows how legal changes aimed at fixing one problem can, arguably, create new challenges or clash with other established principles.
So as we wrap up this deep dive, here's a final thought for you, our listeners, to mull over. Something building on these themes of balance, evidence, and navigating tough accusations that the sources brought up.
Consider this. What does a truly just process look like when serious accusations of SA, SH, or discrimination are made? How do we design a system that genuinely empowers and protects those who need to speak out about harm they've experienced?
While also firmly upholding the fundamental right of anyone accused to defend their name, their reputation, against claims that might turn out to be inaccurate or unsubstantiated.
The really critical question. No easy answers.
Definitely not. And exploring sources like these, even with their conflicting viewpoints, helps us grapple with the complexities.
Absolutely.
We really hope this deep dive into California Civil Code Section 47.1 has been informative for you. And remember, this was part of Teacher Victoria's ESL class.
Yeah, seriously, don't hesitate to drop Teacher Victoria a message about the class, or if any of this sparked further questions for you.
Thank you so much for joining us for this deep dive into the source material.
We really appreciate you listening.